Welcome everybody. This is the Legalities of CBD panel, where we will be discussing the legalities of CBD, the lack thereof, the gray area that CBD sort of occupies in both federal and state law. My name is Alex Berger. I'm an attorney with Emerge Law Group, which is Oregon's first full-service cannabis law firm. I specialize in regulatory compliance, both on the cannabis side and on the hemp side, as well as business transactions and some land use. First thing that I have to get out of the way, this is super lawyery, but I have to mention that none of the information that's given today is legal. It is official legal advice, and none of the information given creates any sort of attorney-client relationship between the panelists and yourselves. Also, I'd like to make this as much of a conversation as possible, so if you guys have any questions throughout the panel, please just raise your hand and someone will come around with a microphone and you can ask your questions, because after all, we're here for you guys. So whatever questions you have, please don't hesitate throughout the panel. We have a lot to cover, not a whole lot of time, so without further ado, I'm going to ask the panelists to go ahead and introduce themselves.
Hi, I'm Henry Baskerville. I'm a managing partner of Fortis Law Partners, a boutique law firm located here in Denver. We specialize in helping small and emerging companies and have a fairly robust cannabis practice. I serve as outside general counsel for a number of cannabis and CBD companies. Well, happy to be here.
Hello, everybody. Thanks for coming. My name is David Bush. I am a senior attorney with the Hoban Law Group. Hoban Law Group is one of a very small number of full-service cannabis law firms in Colorado. We started in Denver. We're now in about 20 states across the country and growing. We also have an international presence. We're in about 6 different foreign countries. We provide all kinds of services, from contract preparation and review to regulatory compliance, and just about anything else you can imagine, with capital raising, tax advice. My practice is almost exclusively on the hemp side. We also have a very sizable marijuana practice. That's where the firm started. But I tell you, when I look at the cases and matters we have coming in the door, they're primarily hemp. So that's really our growth area. I also say that I am a former director of the Hemp Industries Association, the largest, oldest trade association for hemp. I was a treasurer on the board of directors. I was also on the board of our state Colorado chapter of the Hemp Industries Association, and I am currently the president of the Industrial Hemp Research Foundation. That's a 501c3 nonprofit public charity that I founded to raise funds to support hemp education and academic research at institutions of higher education.
My name is Alex Busher. I'm the founder of Busher Law, LLC. We are a firm specializing on the hemp industry. We do everything from cultivation, licensing, all the way to export. Really full service firm. We can do everything from securities, just to general formation. Recently sat on the CHAMPS committee, cultivation committee, which is responsible for helping draft the state plan that Colorado will be submitting to USDA. And I also sat on the Marijuana Enforcement Division Sunset Bill Committee, where we were helping to merge the codes, both the medical and retail codes, for 2020.
Good morning. My name is Corey Cox. I'm an associate attorney with Vicente Cederberg. We are a law firm headquartered in Denver with offices in 5 states across the country. We work exclusively in the cannabis space with the cannabis plant, whether that's hemp, CBD, or regulated marijuana. My practice focuses primarily on regulatory compliance with a focus on packaging, labeling, and marketing.
Good morning. My name is Mark Ross. I'm a founding partner at Mackenzie Ross Ference in New York. I'm probably the only one here who's not exclusively a cannabis lawyer. We do a lot of litigation, corporate financing. I do spend a lot of time in the cannabis space. I started teaching the first law school class in New York at Hofstra University, Business and Law of Marijuana. I'm starting my 6th year on that, so I do spend a lot of time and thought in connection with cannabis, CBD, and the likes, but we do that in the concept of helping companies expand, raise money, how to do it a better way, a smarter way, and protecting them in the process.
Great. So let's start with the basics. Corey, after the Farm Bill was signed, hemp was removed from the Controlled Substances Act, but the 2018 Farm Bill specifically preserved FDA's authority to regulate hemp products, including CBD products, that are ingestible and topical. So can you speak to some of FDA's pretty bright line prohibitions on CBD products?
Yeah, so I think as anyone here, are food and dietary supplements. And so the FDA is of the public position that it is unlawful under federal law to add CBD to food or to market CBD as a dietary supplement. So again, in the eyes of the FDA, it is unlawful to basically add CBD to any product virtually any product someone will eat, drink, or swallow. And so there is I think whether you're a business owner, operator, or consumer, it's important to be aware that there is this very large gap between kind of where the market is and where the regulators are. But, and this is a very significant but, it's really kind of unclear how broadly and the types of CBD products the FDA is concerned about. And so it's unclear this time whether the FDA is concerned with CBD isolate only and believes adding that to food and dietary supplements is problematic, or whether they're concerned with any type of hemp extract with concentrated and elevated levels of CBD, or whether they're concerned with just any type of hemp product with marketable levels of CBD in general. And so the scope of this prohibition is, I believe, intentionally ambiguous on behalf of the agency. Second, it's just not clear that the FDA is actually right on this, on the law. There are credible legal arguments that the FDA is wrong, and that they're wrong on the facts, and that the facts really don't support this position. And so that remains a very ambiguous area, but just understand that this is kind of the FDA's public position, and as a powerful federal agency, I think it's important to understand kind of that's where they're at. Separately, any product that is basically marketed as a drug to cure or treat disease or if address a state of bodily dysfunction could raise red flags with the FDA. Basically, in order to make those types of claims, you have to be an approved drug product. And so regardless of the type of product you have, whether it's ingestible or topical, whether it's CBD isolate or some type of broad spectrum extract, if claims are made on the product that indicate the product is intended to cure or treat a disease, that's something that could raise red flags with the agency.
Yes, sir. Just wait until she comes with the mic, please.
I can hand signal it, so go ahead, ask your question. Ask your question, we can tell what.
Well, it needs to be mic'd.
I can go ahead and repeat the question as well.
So health claims aside, just having CBD as an ingredient or like in your name or anywhere on the label or in your marketing is like a red flag for the FDA.
It
Just
could be.
CBD in the name label.
Potentially. The FDA is, again, I think intentionally ambiguous. There's limited enforcement, but they have said in public statements referred to CBD specifically. And so that is a potential area of
Try
concern
to
with
work
the agency.
the wording, like do the wording workaround, like do a workaround on the wording on your label, pretty much.
Yeah, I think with the labels, and this is something we'll discuss later, the labels need to be a truthful and accurate reflection of your product and what's in it. And so there's only so much flexibility you have with your labels and how to creatively describe your ingredients.
And I would just add that this is all sort of a matter of degrees, you know what I mean?
Right.
So it's all about sort of mitigating to the best of your ability, showing up on the FDA's radar. So using something like, hemp-derived, naturally occurring CBD could be safer than saying CBD isolate right then and there, because that's the ingredient that is in the one FDA-approved drug, which is Epidiolex.
Can I just chime in with a comment?
Sure.
I mean, I think he's 1,000% right. However, the FDA is the authority on it, so there may be reasons that we may disagree with them intellectually and otherwise, but at the end of the day, they're really the ones who are going to create the issues for you. And I think they have been pretty clear in terms of what their expectations are, and right now it's written verboten. Okay, I mean, there's the December 20th memorandum that Gottlieb did before he stepped down that laid it all out. So whether we agree with the rationale, I think it may be challenged. Right now, that's the law that really is governing. And in states, I'm from New York, and and some of the localities have jumped on that and confiscated things out of the restaurants and really have taken issue with it. So I would just be mindful of it. It is the current state of the law today.
And continuing on with the FDA, David, the FDA is a federal agency, and so, under the Constitution, they have the authority to regulate interstate commerce, meaning commerce between states. So if you're selling your products over state lines, the FDA has authority. But does the FDA also have authority over purely intrastate commerce, meaning if you only sell your product within your state, assuming that that state has legalized CBD?
And Alex, I really hear what you're asking as two questions, and I want to answer one in short order and then spend a little more time on the second one. So the first question we can consider is, can the federal government regulate state regulations? Can they direct states to undertake certain regulatory activities? Generally, the answer to that is no. There's been some great jurisprudence that has developed since the 1990s on that very question. It has to do with the 10th Amendment and the enumerated powers to Congress and the presidency under the Constitution. But essentially, what it comes down to is the federal government cannot order states to do anything. That's why we've had marijuana industries. That's why we had hemp industries. It wasn't because of a 2014 Farm Bill. That's a whole subject unto itself. But I'll tell you, the reason that we have the regulated activities we do now at the state level is because states can do it and the federal government can't stop them. So when you're asking, can a state regulate certain activities intrastate that affect food safety and quality and things like that, the answer is yes, they can do that. But the bigger question, which is the second one that I wanted to address here, is does the FDA have authority over activities that only occur within a state under its regulated system? That is a very difficult question, and it has involved a lot of controversy over the years, but basically the answer is you must assume that the FDA is going to be able to regulate activities that even if they only occur within your state. And I'll say that for two reasons. One is I can't even think of any clients I've got who actually only make and sell products within the state. Everybody wants to go interstate. Everybody wants to go international. Most of my clients want to get raw material from Kentucky and process it in Colorado and then ship it to Florida to get bottled and labeled, and then it gets exported to Mexico. I mean, it's an international empire that we are building, and I don't have clients that say, gee, I'm only going to make and sell product within one state. So as a practical matter, that's not going to happen very much. But to the extent that it does, I want to go back to a Supreme Court decision that was decided in 2005, Gonzalez versus Reich, and this is kind of the poster child. Also remember, we are living under the shadow of marijuana. Even if you talk about hemp CBD products, the long shadow of marijuana and its regulatory history and the whole kind of body politic around that, it affects everything that's going on with hemp, including FDA regulation. What happened in that case was there was medical marijuana law that had been passed in California. It's state law. There was a disabled woman who grew 6 marijuana plants at home for her own consumption. She didn't buy anything interstate. She didn't sell anything interstate. She complied with California state law to do everything that she was supposed to grow her own pot for medical reasons and consume it in her home. So basically the stuff not only didn't leave the state, it never left her house, okay? Federal agents came in, grabbed the plants and destroyed them. And that was the case, Gonzalez versus Reich. Did the in that case, the DEA didn't have authority. Under the Interstate Commerce Clause, didn't have authority to go in and mess around with a purely in-state activity under its authority, which is only subject to interstate commerce. And the Supreme Court in that case said, yeah, they did, because they figured there's this comprehensive law out there. There they were talking about the DEA, the Controlled Substances Act, but remember that this same kind of analysis probably would apply to the FDA and the Food and Drug Act. They said it's a comprehensive regulatory scheme. Federal government can do what it wants to enforce its own laws, and if it feels that there's some activity that's only within a state that may affect interstate commerce, that may affect their regulatory scheme, then they have the power and the authority to go in and do what they will to enforce federal law. So in that case, this poor disabled woman growing 6 plants in her home, never left the house, she lost. So my word to you is, we don't know. We don't know, but we must assume that the FDA is going to be able to regulate all activities regarding hemp CBD products. Number one, because as a practical matter, they're likely to go interstate anyhow. Number two, even if they didn't, there's plenty of federal authority out there that says if the feds think that is going to have some impact, direct or indirect, on interstate commerce, they can still come in and do something about it.
Personally, I think that Supreme Court decision was crazy. I think it violates federal principles. But I would also just add, I would just draw one distinction, which is in the federal law that grants the FDA the authority to regulate ingestible products, the Food, Drug, and Cosmetic Act, many of the listed prohibited acts that the FDA quotes in warning letters that they send to CBD manufacturers specifically call out introduced into interstate commerce. So I think, like I said, you know, it's a matter of degrees, but I think you do provide yourself, you know, if you're a smaller mom and pop shop who's just getting started, I think you do provide yourself a little bit of extra cover by keeping your activities intrastate.
I've got one more thing to add to that, because since you talked about race, and we do talk about race in my class, race was challenging of the CSA, and it did uphold it. So basically, the conclusion was that, yes, the federal government, and it was the Commerce Clause, and it really was, if you study it, it really was the evolution of the government trying to get what it wanted to accomplish regardless of. So race is an admonition to everybody saying that the federal government is here to stay, and you ought to be concerned with it. And if not, you have the Controlled Substance Act, which is federal law, which makes it illegal today, so you still have that. But I totally agree.
And Alex just raised a point, I just wanted to amplify that too. Who doesn't sell product online? I don't think I have any clients who don't have a website and don't invite people to log on and buy their products. So even if they're really only making the products in one state and have brick and mortar kind of stores and things like that in one state, if they've got a website, believe me, they're in interstate commerce. So once you take that step, there's no turning back. And that raises your exposure, that raises the breadth of your market, and it invites regulatory scrutiny. I'm not saying don't market online. I'm just saying those are the inevitable consequences of marketing online, that suddenly you are in an interstate market, whether you really intended that or not.
So Alex, the FDA has largely made public statements about ingestible products such as gummies, tinctures, things of that nature. So I know that a number of my clients are starting to produce hemp-derived extract cartridges and even usable hemp joints, pre-rolls, things like that. Would you say that the FDA has the authority to regulate those items as well?
So I think there's a clear answer to this with two caveats. As always, being a lawyer. So first, I don't think that currently, with the FDA positions they've taken, that they have the authority to regulate hemp vape cartridges and hemp cigarettes, as long as there's no tobacco products in them. FDA has clear authority to regulate nicotine because they have interpreted tobacco to mean any tobacco derivative, which includes nicotine. So if you're mixing your hemp with nicotine, you are likely going to be, or the FDA has authority over you because of their authority over tobacco. If you just have hemp cigarettes and hemp vape cartridges, it's much more unlikely that the FDA has authority unless you make a medical claim. Because as soon as you make a medical claim, you've now made yourself a drug, your product a drug, and now you've put it's a misbranded and adulterated drug, potentially in interstate commerce. So that's the one caveat would be the medical claim, and the other one is FDA could always find a section of law, I haven't found one yet, where they could really just say, oh, we can interpret this as we can regulate any smokable product, but under Chevron deference, agencies have a lot of latitude in their interpretations. So just because they're not saying they can regulate it explicitly today, doesn't mean that tomorrow they don't find some section and reinterpret and say, oh, well, now we have authority over hemp 2 and all smokable products. I don't see that happening yet. I haven't seen haven't heard anything about FDA moving that direction, but agencies have a lot of authority, and as we've seen with DEA and other agencies, a lot of times they'll act first and deal with the repercussions later. FDA hasn't been as aggressive about that, but it's always a risk. So the answer is currently, I do not believe they have the authority to regulate, but that's not saying that they couldn't find a way to believe they have that authority.
So I just want to open this up to the entire panel, but can we talk a little bit more about medical claims, what that means? Does that only apply to labeling? Does it only apply to official marketing materials, or does it also apply to, things like social media and consumer testimonials and things like that? What is a medical claim?
So the FDA has made very clear that anything that you put on your website, including testimonials or even links to other websites with medical information, will be taken by them as an adoption of your company of that statement and then imputed onto your label. So anything you put out on your website, social media, anything with testimonials, anything with even links to other websites have been found by FDA to be medical claims, and then companies have actually received letters just because of those testimonials or links to other websites.
Yeah, and if I could add it, I think it's important to hear that the FDA, when they are regulating products and determining what's a drug, what's a food, dietary supplement, they're less focused on the kind of physical characteristics of the product than they are the intended use of the product. And so to determine what the intended use is, the FDA looks at the labels, they look at the websites, they look at everything Alex just mentioned. And if when the FDA is reviewing these materials, they determine this product is intended for use as a drug, that's when you can face challenges from the agency.
It looks like we have a question here, sir.
Hi, thanks. My question is about testimonials and comments. We've had customers make YouTube videos and stuff like that we have absolutely no control over. So if they're testimonials or whatever that aren't on your website, are we concerned about those?
I'll jump in on this. So I would say that if you've linked in any way or promoted that testimonial in any way, and there's a paper trail or a link trail back to your website, you would have some liability. But if you have a customer who's just expressing their experience with your product and you haven't promoted or adopted that statement in any way, I don't believe that would implicate your company.
I agree with that, and the answer is you're not the police for the world, so you don't have the obligation to go onto social media to monitor it. You have the obligation, once it becomes known to you as being suggested, to take action and certainly not endorse it.
Yes, follow-up question.
Sorry, it's an unrelated question. We've been talking a lot about the FDA, and I know that's important. Have you seen any, as far as the DEA is concerned, are we seeing a lot of hassles out there lately?
In my experience, frankly, no. I've not seen any post-2018 Farm Bill DEA enforcement. I know that I believe that DEA has helped sister agencies test hemp that has been suspected as being marijuana, I believe in a West Virginia case and also in an Idaho case, possibly in an Oklahoma case as well. But in terms of DEA raids on sort of official hemp businesses, I haven't seen any enforcement post 2018. I don't know if any of the rest of the panel has.
I want to add something to the discussion we just had about medical claims. that's part of what you need to be aware of and be very careful about in selling and promoting your products, that you don't make claims that the product will treat, diagnose, mitigate a disease. But there's another whole area you have to be aware of too that's related to that but not the same thing. With drugs, they're supposed to treat, diagnose, mitigate disease. But there's this whole realm of dietary supplements, and that's what most of these products are pitched as. Well, with dietary supplements, you can, if the statements are approved by the FDA, make what are called structure-function claims. What we see all the time is clients of ours that are making structure-function claims that have not been approved. And that invites the same kind of regulatory scrutiny and problems with the FDA, potentially, as do medical claims. What's a structure function? That's things like builds healthy bones, helps you sleep better, maybe even puts you in a good mood. There's all kinds of things where a product can affect how the body operates without necessarily curing you of something. Those are structure function claims, and you have to be very careful not to make those too. Especially if you're pitching your product as a dietary supplement, trying to stay away from drugs, you can just fall into another trap there.
So, Henry, I know that there has been a lot of pressure from Congress and from the Senate to have the FDA change its regulations and find some way to expedite approval of CBD products. Can you speak to what you think that will look like, possibly, and how long it will take the FDA to come out with regulations that may ultimately be friendly to the industry?
Well, the FDA said in August that it intends to regulate CBD, hemp-derived CBD and other hemp products the same way that it regulates food and drug, which gives about as much clarity as mud. But and who knows how long that will be? I mean, it's the same thing with the USDA. That the Farm Bill says that the Department of Agriculture is supposed to promulgate regulations in order to enact the 2018 Farm Bill. They've said that they want to have those regulations in place by the fall of 2019. Of course, today's October 12th, and we still don't have those. So I don't know when the FDA intends to better or to regulate at all CBD, but I know that they intend to do so the same way they do drugs, supplements, and food, and there's a wealth of information about that, and it could be that it's regulated in both respects. I mean, there's examples of that. Turmeric is regulated both as a food when it's a you put it in as a spice, but it's also regulated as a supplement used for a variety of different ailments. It looks like we have a question. I think you need the mic, sorry.
Thanks. Can you share your perspective on the current legal situation with hemp-derived CBD in cosmetics?
Right now, my understanding is that topicals, the FDA has said that it's not, they are not prohibited under the FDA's rule. Right now, the FDA is cracking down on ingestibles, but topicals, lotions, and so forth, you can put it in there. You can't make any medical claims. Same issue.
Yeah, just to piggyback on that a little bit, my understanding is that the FDA does not require pre-approval before you put a topical or cosmetic onto the market like it would with a drug or a dietary supplement. But there are still regulations that require that topicals and cosmetics are not adulterated or are not harmful to your health. So, but generally, I think it's a lot safer way to go than, say, an ingestible.
And that's why you're seeing the topicals pop up at Walgreens and Whole Foods and CVS, is because the FDA has pretty clearly stated that right now they're not going after topicals. And you'll actually see CBD labeling on topicals and CBD isolate put into topicals because of that, whereas isolate and CBD labeling in tinctures are much more risky, and CBD labeling should not appear on tinctures in general.
And just to kind of piggyback on what was said here, what you have to be careful about with cosmetics is, are they being marketed truly as a cosmetic or as a delivery device for something else that could be considered a drug? So if you just have a moisturizing cream, and all it's going to do is kind of make you feel good and look good, that's a cosmetic. If it's a medicated cream, if it's something that is being peddled to treat a skin rash, for example, now you're talking about a drug. Okay, even though it's a cosmetic, it kind of morphs into that other category. So you have to be very careful about what the product is and how you're pitching it. And if it's just a moisturizing cream, that's a cosmetic. If it's just a cleansing, this is another thing. If all it does is clean, that's fine. Then you don't need, as Alex was saying, pre-approval. Okay, because there's a lot of things the FDA says you can only do it if we approve it first. Cosmetics is not one of those. Cosmetics, you can just market those, you can make them and market them as long as you follow the labeling requirements and as long as it doesn't morph into a different kind of product, like a drug.
And there's even more nuance with this. A lot of topical companies are trying to put out sunscreens. Sunscreen is inherently a drug. So now, it gets very, very complicated. So putting CBD into any sort of cosmetic that's going to be used as a sunscreen or has any sunscreen ingredients, that makes it a drug product. So that's another area to stay away from.
Sir. Oh, we have a couple of questions.
Yeah, I just had a quick question. I'm a small business owner, and I wanted to go back on the FDA, like food consumption about it. I bake with it, so I sell baked products with CBD in it. So should I have any concerns with pre-approving any of that, or?
You can't pre-approve it. As of now, the FDA will not pre-approve any ingestible that has CBD in it. So, that's the rub here, right? Is that according to the FDA, if it's something that's put in your mouth and swallowed, it should not have CBD in it. Now, of course, we all know everybody's doing that, and
Right.
so you just have to be careful. I think you have to keep in mind where you're shipping to. My clients, I tell them all the time, you need to have a list of the states you're shipping to, because truly, as long as you're not making, this is not legal advice, but as long as you're not making
Right.
medical claims in large respect, especially small businesses, the FDA is probably not going to be your problem. The bigger problem will be that potentially state regulators or it may get lost in the mail. I've had a number of clients, probably people in this room have had the same issue, where a a package just doesn't show up, or whether it's because the post office just confiscated it. I had a client ship a sample of isolate to Florida, and I've never seen this before, but he shipped it via FedEx, and when you go on the FedEx website and look at the tracking, it says it was signed for by the police. and the people in Florida called me up, and they're like, "What should we do?" And I said, you have the COA. It shows that it's legal. It shows it has no THC in it. You go to the police station and tell them to give you your property.
Right, okay.
And we called the police and talked to them, and they gave it to them. But a little thing of isolate, it's a bunch of powder. They probably were concerned about it. So, to make a long answer short, technically speaking, you can't get approval by the FDA, and what you're doing is, in their view, illegal. But in practical terms, everybody's doing it, and you just got to keep in mind that that's part of the business, that you may lose some product.
Okay.
The one thing I would add to that is to know your state laws as well, because there are many states out there who rather than creating their own food and drug laws, they adopt by reference the FDA regulations. And so those states, including California and I believe New York as well, they basically, toe the same line as the FDA. I happen to be lucky to be in Oregon, where specifically in our food law, it says hemp and hemp derivatives are not food additives under food law. So you're free in Oregon to add CBD under state law as well, but it's important to know your state laws.
And I would add to that it's important to know the state law regarding hemp as well, not just food and drug law, because there's still some states where if you would send any product containing CBD, it's marijuana, and it could actually be considered hashish because it's an extract from marijuana. So you could be sending a CBD tincture into Idaho or South Dakota, and they could charge you with trafficking hashish. So just really know your state laws.
Sir?
I'm a digital marketer, and I would love to know, or have you addressed the legality of sampling and free trials of CBD?
Yeah, I think this is just the kind of product and what the product is. You know, the FDA restricts the ingredients that can be used, kind of how they can be marketed, how they can be sold. And so I think with sampling, you know, the FDA will determine kind of whether they view the product as legal. And then for the sampling, you'll be looking at, I guess, consumers, kind of whether that's lawful in the state. So I think the FDA would evaluate the product, whether that's legal, and then your state law would apply to kind of whether that product is legal within the state, how it can be distributed within that state.
Yeah, the only thing that I would add is that the Food, Drug, and Cosmetic Act does not strictly say sales when it says prohibited acts. It says the delivery into interstate commerce. So as soon as you deliver a prohibited product, regardless of whether you make any proceeds off that product, if it is indeed a prohibited product, then technically you are still breaking the law and FDA regulations.
So I have two parts, two questions, and it has to deal with the FDA's ability to issue warning letters. So the first one is, so far as I've seen, is all the warning letters coming out of the FDA has been primarily against claims on people putting stuff on their websites. So they're claiming websites, so there's a warning letter that actually causes them to step in and say, stop doing this. So with that, what is, if, my website's not one of those. So if I were to issue a warning letter, what would I have to do? Just simply take the website down, rewrite the website? Are there penalties? Are there fines? Is there jail time?
Okay, so I'm just going to repeat that question because we missed the tail end of it. So I believe the question is that, relating to warning letters that the FDA has sent to manufacturers, largely triggered by medical claims that have been made on websites, et cetera. And you actually stole one of my questions. That was one of my prepared questions at the end. So the question is, what does a company who receives one of these warning letters, what do they have to do? Now, what I've seen from the warning letters themselves is that the FDA will either take a sort of rebuttal comment, and you can say, no, this is why my product is not actually illegal, or something of that nature, or they will ask you to take down any of the comments that are on the site that they point out or any of the medical claims. But I have to say that there are a number of businesses out there who haven't done anything.
Yes.
And the FDA has very limited power to actually go out and arrest people. They have to consult with the DOJ ahead of time. They frankly don't have the resources. I mean, they're not like the DEA. You're not going to find somebody with, FDA emblazoned on their vest or whatever, breaking the door down or things of that nature. I'd be interested to see what the panel has to say as well, though.
Yeah, I think that's right. I mean, one of the interesting thing is that the 2018 Farm Act, everybody thinks it just made everything legal, and it's really not even been implemented yet because the U.S. Department of Ag hasn't promulgated rules yet. But one of the things that I think it really did that's important was take hemp and hemp-derived products out of the purview of the DEA and put them in the purview of the FDA, because, as Alex said, you're talking about two completely different departments. One has significant resources and, people with guns. The other one doesn't. And I think another part of your question was, you said that you've just seen people getting warning letters for claims that are only on their website. And I don't think that's entirely true. I mean, it certainly, claims on your website is something that's going to raise the ire of the FDA because it's easy to find. But if you have medical claims on your labels, if you have them in your social media, or if anybody was advertising on TV or something, anywhere your company is advertising your product, if you're making medical claims, you may raise the ire of the FDA. It's just websites are a lot easier to find.
We don't have too much time left, so I want to switch gears really quickly. And Mark, I wanted to address this question to you. I know that a lot of my clients are having a lot of difficulty finding banking partners and being able to process credit card transactions. I don't know if the audience knows this, but the United States House of Representatives recently voted on the Safe Banking Act, overwhelmingly they voted for it, which would protect marijuana businesses in state legal, with state legal regimes. It would protect banks that do business with them. And I was wondering if it similarly affects hemp businesses as well.
Well, I think the answer is it does. And, first of all, I've had conversations, because we represent a lot of companies that have raised money, and I've dealt with some of the banks, and I deposited cash from a CBD company, which is 100% legal. There's no banking issues associated with it, even though, as you said, the SAFE Act even carved it out, made it even clearer that CBD is exempt from it. But notwithstanding that, the bank has turned around and said you may not put the deposits into the account. Now, I'm not sure whether it's really a KYC, know your customer issue for the banks, because that's really the big issue as it relates. You have to, the banking has an obligation to understand the people depositing the money into the account to trigger, or it triggers reports, or, which I think really is the case, just most people are lazy and stupid, where they just don't want to be bothered to really figure out what the difference really is. And I will tell you, from my conversations with the banks that I've dealt with, it seems to be the latter. Because when you can demonstrate to them, and I've gotten on the phone with them and I've demonstrated to them it's a 100% legal product, it's not cannabis, it's not a Schedule I drug, they're still not interested in learning the difference. Now, with regard to card processing, I was speaking with a couple of different people here yesterday. Some people have no problems with card processing, and some people have problems with card processing. I think what most people in the industry are finding is that, if you're smart about it, you can generally get things done. What does smart about it mean? As someone said earlier, don't say CBD. If you're doing cannabis, you don't say cannabis. You have the relationship with the bank, with the card processing company. The real issue here is whether or not it is federally legal, which means it has less than 3% THC. Now, how do you demonstrate that? Creates kind of the confusion, if you will. But if it, in my opinion, if it has less than 3% THC from industrial hemp, it's 100% legal, is a federal level, and it should not be an issue.
Now, of course, the problem with that is, as many of you have probably found, a lot of the big banks don't care.
Ergo lazy and stupid.
Yeah, and I think it makes sense to be smart about it. Now, if you want to have your company be named, CBD World or whatever, that's fine. That should be a DBA. You should have the name on your actual company be something like, BC LLC or something totally innocuous, and then it can be a DBA weed, right, or whatever. And I think that'll help with a lot of
Don't get
banking.
the checks in the name of weed.
Exactly. I know a lot of my clients have on their invoices, we do not accept wires for anybody with CBD or cannabis or THC in the name. And that's just because, sometimes a bank, even if you're doing everything right, you get a wire from somebody whose name is THC LLC, and your bank is going to ding you, and they're going to kick you out. You're going to have to go find somebody else. Hopefully, the SAFE Act will be passed by the Senate and signed into law by President Trump, maybe. And that would make things a lot easier, even in states like Colorado, which have been largely solved by local banks that have stepped in and taken business for dispensaries and so forth. I think it will help substantially here because, as some of you may know, the banks that are really cannabis friendly charge an arm and a leg for that. And so if it becomes federally allowed, more banks get in, competition will drive those prices down.
So I had an opportunity to work on the safe banking ancillarily, and initially the bill only related to marijuana because they defined cannabis-related business as marijuana business. There was a major issue with that because we knew that if it got to the Senate, McConnell wouldn't take it up. So for two reasons, hemp was added in. One, because the hemp business, Elevon had just exited the market at this point. Nobody was able to get processing, so we really wanted to make sure that banking was available for hemp. But two, McConnell, being from Kentucky, he has a lot of Kentucky hemp farmers behind him who also are having trouble getting banking. So by adding that hemp provision in, it'll put more pressure on McConnell to bring it to the floor, especially in a primary year.
So we only have about 2 minutes left, so I'd like to open it up for questions.
There was discussion with the two agencies, the DEA and the FDA. An attorney friend of mine had raised the question of the FTC, and I'm wondering what your perspective is on that. With his agreement that the FDA didn't really have any enforcement aspect, but if it got to the FTC, they would show up.
Well, the FTC certainly regulates any advertising, and so they are going to work hand in hand with the FDA in respect of making medical claims and so forth, and regulating what you put into the into your advertisements and on your labels and so forth.
Yeah, and I think about this is the FDA is going to regulate claims that are on your label. They can look to your website to determine intended use, but really the FDA is focused on the claims on your label. The FTC is focused on the claims you're making everywhere else. And in the last month, the FTC, has issued, I believe it was 3 or 4 warning letters to CBD businesses for the claims they were making and not having the required kind of documentation or evidence to substantiate the claims they were making. And so I think the FTC is one federal agency to kind of add to this alphabet soup of federal agencies that are out there and scrutinizing this industry.
They're not regulating the same thing, but they overlap tremendously. So the FDA has rules about things that people can say and things they're not supposed to say. And that's what they try to police. The FTC, mainly what they do, or their interface, I guess, with the cannabis industry, especially hemp, is truth. They're the truth police. So you can't make statements that are untrue or unsupportable or unsupported. That's where the FTC may come in. So you may make a medical claim, and that could implicate FDA authority to say, oh, you can't make medical claims. The FTC could come after you saying, you have no backup for that. You don't have any evidence that you have collected to demonstrate the truth of that statement. So they're kind of regulating some of the same things, but in different ways.
So at the end of the day, lazy and stupid is bad. Making claims is bad. Making medical claims is bad. Unless there are any other questions, it looks like it is noon. And, oh, sir, you had a question? Just 1 second here.
I'm curious about smokable flower and interstate with smokable flower, maybe the calling it CBD flower compared to hemp flower on a label, and then the delta 9 THC to total THC. Where is that landing and where is that going?
So I'll start first with the smokable question. Like I said earlier, FDA right now has not asserted authority over smokable hemp. So labeling isn't going to matter as much. What does matter is who you're sending it with. I've had clients that have gotten held at gunpoint for sending smokable hemp through the mail through FedEx because it looks like marijuana flower. So the police see it, they don't have an ability to test right away, think it's marijuana, all of a sudden your client is on his knees at gunpoint. So making sure you know who you're shipping through. USPS has put out guidelines for shipping hemp through the mail. Definitely follow those guidelines, have your COAs, have your licenses, and then I'll let somebody else discuss the Delta 9.
So in terms of Delta 9 THC versus total THC, the farm, both the 2018 and 2014 Farm Bill talk about Delta 9 THC. Like, for example, THCA is not regulated by, is carved out of the Controlled Substances Act. So total THC, from what I understand, is not really the relevant question. It's Delta 9 THC.
I actually heard something a little bit different than that based on the language in the 2018 Farm Bill of how the federal government is going to test for THC. My understanding, and I'm not a scientist, but my understanding is that the testing language in the 2018 Farm Bill states a decarboxylized test, which suggests that indeed, at the very least, that's how the Oregon Department of Agriculture is interpreting the 2018 Farm Bill. And so, as of January 1st, 2020, the Oregon Department of Agriculture is requiring tests for total THC, which is the addition of Delta 9 THC and THCA. I think that question will be answered more definitively when the USDA comes out with its regulations, but that's been my understanding since the publishing of the 2018 Farm Bill.
And
I'd welcome comments from the rest of the.
Colorado businesses, it's been Delta 9 THC plus THCA for the last 2 years. And it's because of 0.875, so with the conversion. But there's a question about the rulemaking, and I think, like you said, we're going to see USDA come out. Because it's a decarboxylation method, most people are using gas chromatography, which is taking that THC and converting it into THCA, converting it into THC, and then you're getting that total.
And by the way, one more thing that I'll say really quickly is that I believe in the Farm Bill it does say or reasonable equivalent as well. I know that that drafters of the bill really pushed to get that in there because at some point there may be scientific methods for testing that would only test Delta 9 THC, but again, I think that remains to be seen when the USDA finally publishes its regulations.
I have one quick takeaway. I'm sorry. I have one quick takeaway for everybody. The important thing is really going to be certification, to be able to demonstrate what it is that you're shipping, and to whether it's going to get you away from gunpoint, as someone else here said earlier, or when you go to the police station to get your CBD back legally. I think a very important message to take out of today is make sure you have the proper certification.
And
There's a deeper problem here I just wanted to point to, and the question about smokable hemp really highlights this. There's a practical issue, and then there's kind of a deeper legal issue I just wanted to point to. With smokable hemp, what you have is the sweetest, best part of the plant, right? It's been conditioned, what you're shipping. You don't have any sticks in it or twigs or even lower leaves, right? It's the best of the plant. And I say that because what that means is what you've got in shipment is probably not what was actually tested in the field and approved in the state of origin, where they may have had some sticks and seeds and less potent leaves that were all kind of mixed up and tested. There's a very good likelihood that what you're shipping is actually going to have more than that legal threshold of THC in it, simply because it's a concentrated, very sweet part of the plant. So that's a practical observation. Now, here's the deeper legal issue. I got a driver's license that I got in Colorado. Okay, I was married in Colorado. If I drive across the state line and I'm stopped in another state, my tail lights out, and I show them my Colorado driver's license, nobody is going to say, oh, you have a Colorado driver's license? Well, you're in Missouri now. You're going to have to take a driving test in order to drive in our roads. No, they accept my driver's license from Colorado as good. They accord that full faith and credit. I may have some other issue with being stopped, but not the license. Same deal if I move to Missouri and I get a job and I want my spouse to have benefits with my job, health insurance and stuff. They don't say, oh, you're going to get married again in Missouri because you only had a Colorado marriage. No, again, full faith and credit, they accept my Colorado marriage. That is not happening in the hemp industry. You cross state lines with something, and what's law enforcement? The first thing they want to do is test the stuff. Now, wait a minute. It was tested. And if you test it now because of what I just described, it's probably going to blow hot. And then the material gets seized. We have a really messed up system. We have to have states that are accepting and recognizing what legal states of origin did, accept those as legal acts. What you've got is a legal product that was approved in that state. It should get a pass, and we're not there yet. That's a significant problem. It's a deeper problem, and it really affects products like smokable hemp.
So we're about 5 minutes over, so we're going to stop for now, but I'm going to hang around. Well, but thank you very much for